Fall down cases can be very difficult. These are also called premises liability cases. Today, I'd like to explain what I look for in evaluating a personal injury, premises liability, slip and fall, or trip and fall case. Hi, I'm Guy DiMartino. I am a Northwest Indiana personal injury lawyer, and here you go. The first thing that I'm going to ask you is, why did you fall? If the answer is, I don't know, you don't have a case. If you're able to articulate why you fell, we go to the next step and try to determine the facts and circumstances regarding the case. For instance, if you say, I was walking into an apartment complex and the owner of the apartment complex failed to salt the area and I slipped on ice, then you could potentially have a case and you can potentially show liability against the owner or possessor of the property. Another example would be that you were walking through a commercial parking lot at night in a shopping center and the lighting either turned off early or the lighting was bad or the lights were broke and you stepped into a pothole and you twisted and broke your ankle or you hurt your knee or you hurt your hip or you fell on your shoulder. At that point in time, we can go ahead and at least initially believe that there's some type of liability or responsibility on the property owner or the property manager. So you need to be able to, number one, articulate what happened and why you fell. If you were to come in and say, I was walking down the aisle and the next thing I know I was on the floor and I don't know why I fell, we cannot prove your case. Why? Because you could have tripped over your own feet. Why? Because you could have not been paying attention. However, you say, I was walking down the aisle and the next thing I knew I was on the floor. And then when I was on the floor, my seat was wet, or I saw there was leaking from a Coke machine, or there was a bottle of water or Coke or something that was broke and it was dripping on the floor, then we would be able to go ahead and move forward with the case because we have some type of theory of liability or responsibility on the store or the owner. So that's the first thing. Liability. Are we able to show that the property owner was negligent in some way? The second thing that we need to try to understand is, were you injured? See, we are a personal injury firm. If you fell down, you hurt yourself, and a day later you were fine, there was nothing that we can really do in order to get you compensation. That would be a claim that you could pretty much handle with the store. Maybe they'll give you a gift certificate, pay your medical bills if you went to the ER that day, and then you can go on. However, if you were injured, if you broke something, if you needed therapy, if you had to go in for surgery, then you have significant enough damages to get a lawyer involved in your case. So there you have it. The two things that we need to know is why you fell. In other words, what did the store owner or the property owner do wrong? And were you injured? If you have any questions regarding a Northwest Indiana premises liability, slip and fall, trip and fall type case, you can always reach out to me. I am Guy DiMartino. Have yourself a great day.